Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be talking about today or anything else in the world of consumer financial services, please don't forget about our blog, consumerfinancemonitor.com. We've hosted our blog since 2011 when the CFPB became operational. There's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you access your podcasts. And also, please let us know if you have ideas for any other topic that we should consider covering on a future podcast show or speakers that we should consider as guests on our show. This brings us to today's speakers, who I don't think that anyone who's attended any of our webinars over the years, and particularly webinars pertaining to student lending or litigation, aren't going to know John Culhane. John is a senior partner in the Consumer Financial Services Group, a regular panelist on our webinars and a participant in our podcasts. And in the higher education space, which is one of his areas of concentration, John really covers just about anything in the world of consumer finance, but has a particular focus on higher education or student lending. His practice involves providing regulatory advice as well as assisting in the defense of government enforcement actions and private litigation. Let me also introduce our co-panelist today, Tom Burke. Tom Burke is also a partner in the Consumer Financial Services Group. He represents financial institutions and loan servicers and class actions and enforcement actions all across the country. Tom is an honors graduate at Harvard Law School. He served as a prosecutor in the Manhattan District Attorney's Office, and his practice focuses on student lending and student loan servicing, also on residential solar lending and payments fraud. And just last month, Tom was ranked among the top litigators in the country by Chambers USA. Moving on we're up to the agenda, and this is the point where I will turn the program over to John and Tom.
Thanks, Alan. So I'll be kicking off the first topic. I'll walk through our agenda very briefly. We are going to cover, of course, the One Big Beautiful Bill Act, which is probably the most significant student lending litigation that we've seen maybe since 1993 when the direct loan program was created. We will talk about student lending litigation developments over the past 6 or 7 months. John is going to cover state legislation that is in a variety of different stages of enactment, and then we will talk about private student loan litigation more briefly. The One Big Beautiful Bill Act. Of course, we've all seen it in the news for quite a lot of reasons, because it has many, many areas of substantive impact. It became law on July 4th, 2025, when President Trump signed it into law a few weeks ago. And as I mentioned earlier, it is almost certainly the most significant congressional action on federal student lending since 1993, when the direct loan program was created as an alternative to the FFEL program. There are many areas of very significant impact. I'm sure that we have many audience members here who are interested in certain discrete aspects of its impact. We are going to cover it at a broad level, and if you have more particular questions, you can certainly follow up with us afterward. Probably the most significant operational change for federal loan servicers, and by extension, one of the biggest policy impacts, is the fact that the Act consolidates repayment options from what had become a truly dizzying array of alphabet soup repayment plans over the last 20 years. That would include income-based repayment, income-contingent repayment, payee, repayee, and many others. It consolidates them all down to just two repayment plans. The standard plan, which is your classic mortgage-style plan involving fixed payments over 10 to 25 years. And when you finish paying, you're done. You've repaid your loan. So that one is conceptually pretty easy. And the second is essentially an income-based or income contingent plan that rolls up all of the previous many plans of this nature into one single plan. It's called the repayment assistance plan. So for all of those public servants out there, payments on this plan are PSLF eligible, which I'm sure will be good news, and of course makes sense in light of the fact that the PSLF program, which was enacted in 2007, is still good law. It allows for income-based payments over a 30-year term, which is a vastly extended term as compared to most of the previous income contingent plans. It allows for principal matching, which a lot of people are not aware of. If you make certain payments, your principal payments will be matched. There will be a waiver of unpaid interest every month. And those last two things are important primarily because they address the concept of negative amortization that had become a major problem under the previous income-based repayment plans. Borrowers make payments for 5 years, 10 years, 15 years, and they would say, I've been making payments this whole time. How did my balance go up? And of course, anybody who's familiar with accounting or general lending principles knows that if you're making scheduled payments of less than the interest that accrues every month, then not only will you make no dent in the principal, but you'll accrue a higher balance. And because the federal loan program provides for interest capitalization at many different times, many borrowers face ballooning principal balances. Now, like the other previous plans that this is replacing, the repayment assistance plan does allow for loan forgiveness after completion of the term. So most borrowers in this plan will slowly chip away at their principal balance. It won't be enough to fully repay it by the end of the term, but they will be eligible for loan forgiveness after 30 years. Now, another key facet of the One Big Beautiful Bill Act is that no new repayment plans can be created by the Secretary without congressional approval. So over the past few years, one of the most ambitious things we saw the Biden administration try for was the introduction of the SAVE plan. And we'll get to the way the courts have treated that a little bit later in the program. But it basically allowed for a tremendously low repayment rate over time, only a very small fraction of discretionary income, and it meant that many borrowers would actually have a $0 payment. So this was a loan repayment plan only in the very loosest sense of the word. And Congress here has said, nope, no more of that. So regardless of the administration going forward, unless they can convince Congress to take further action, these will be the two repayment plans that borrowers are going to be choosing between on their federal loans, just these two. The One Big Beautiful Bill Act eliminates certain kinds of deferment for unemployment or financial hardship. And importantly, it limits loan forbearance to only 9 months out of any rolling 24-month period. And that's important because over the last decade, we have seen many borrowers placed or requesting long-term forbearances, by which I mean forbearances of 24 or even 36 months, where they were accruing interest for much of that time. And the impact on their loan balance was very hard to recover from. There are major new caps on graduate and parent loans. And to anyone here who is attending from the private lending side, I don't think it's a novel comment to say that this is going to open up significant new lending opportunities to borrowers who would have otherwise looked to federal loans, and instead now they're going to be looking to the private sector. They'll be subject to underwriting, but there is still going to be a massive amount of demand for loans of this nature. We'll also get a little bit later to some of the impacts, the potential litigation risk that arises in that context. And then last, there is what has been called a do no harm test for degree program eligibility, where if program statistics determine that a borrower is making less money after graduating than they would have if they did not go to that program at all. In other words, if they're doing worse as a matter of income as compared to the baseline non-attendance scenario, then that program may no longer be eligible for federal loans. And that'll have a tremendous impact on certain market segments if their programs do not leave their graduates in good standing. One important note on that is that only borrowers who complete the degree program count for purposes of this statistics tracking. So you can already foresee a wave of lawsuits relating to allegations of undue pressure to drop students from those degree programs. They don't count toward those financial statistics. It's going to be something to really keep an eye on if you interact with institutions where that is a consideration. There are a few less significant changes that take immediate impact. The IBR plan for the remainder of its existence over the next year will no longer require partial financial hardship. The Biden borrower defense to repayment regulations, which have already been delayed, will be further delayed until the 2020 status quo is restored. And then the Biden closed school loan discharge regulations are rescinded, which restores the 2020 regulations there as well. So there have not been a huge volume of reported significant decisions in the student lending space this year, but there have been a couple. And I would like to walk through a few of them. In the interest of disclosure, Ballard has been involved in some of these cases. We were not involved in the first case referenced here, which is Missouri v. the Department of Education. This relates to the Biden-era SAVE plan and efforts by a group of Republican state attorneys general to have that plan invalidated. Now, the SAVE plan is now a dead letter, not just as a matter of case law, but because Congress has spoken and it will not be part of the repayment options going forward. However, there is some really important rhetoric in one of these decisions that I think is probably important and may be useful for many institutions that could find themselves as defendants in cases in this space. So in June 2024, the trial court entered a nationwide injunction, something that we will now be seeing less of following the Supreme Court's recent opinion on that topic, to prevent the implementation of the SAVE plan loan forgiveness provisions. It concluded that the implementation of SAVE likely presents a major question. The major question doctrine is something that we're all familiar with from the 2023 decision relating to the Biden loan forgiveness effort, where the idea is that if a question of law presents major commercial, socioeconomic, or other societal questions, then we need Congress to speak with exceptional clarity on it. And at the ordinary level of clarity on less important questions is just not going to do it. So where the executive branch purports to act pursuant to a grant of authority, it has to be very clearly articulated. And applying that standard, the trial court concluded that the Higher Education Act, which is what the Biden administration was trying to use to enact the SAVE plan, does not provide the clear congressional authorization that the major question doctrine requires. So this ping-ponged up and down in various jurisdictions and various circuits for several months. In August 2024, the Eighth Circuit entered another preliminary injunction that stopped the department from doing very much over the months between the waning months of the Biden administration into the early months of the Trump administration. And then in February 2025, and this is the opinion that's cited up above, the Eighth Circuit affirmed the nationwide injunction. And there are many, many sound bites in that opinion that are worth paying attention to. But the one that struck me is the Secretary of Education must design ICR plans, income contingent repayment plans, leading to actual repayment of loans, but has gone well beyond this authority by designing a plan where loans are largely forgiven rather than repaid. And so this gets back to the heart of what Congress originally intended with the Higher Education Act and the FEL program and the direct loan program. And of course, over the past 15 years, probably, we've seen the repayment plans become more and more less likely to result in repayment of loans. Now, the argument has always been that where Congress intends to allow for loan forgiveness, such as public service loan forgiveness or other limited categories, it says so. And in fact, we now have Congress on the record eliminating things like the SAFE plan that provided for more generous forgiveness or cancellation. So the Eighth Circuit, I think, was on the money in terms of having their finger on the pulse of Congress's intent, and we've seen that play out. In the aftermath of that opinion, there has been what I will generously call consternation over exactly which repayment plans and forgiveness options exist until that July 2026 implementation of the One Big Beautiful Bill Act plans. So the Trump administration initially reverted to the alternatives to the SAFE plan, such as IBR and PAYE and ICR. And they recently paused many aspects of those plans and put those borrowers either in forbearance or have said that they're not going to move forward with forgiveness under those plans. The latest that I have seen on this is that the department's directives have been anything but clear. And the reason I mention it is because whenever this happens, by which I mean the early pandemic era cessation of loan payments or the return to repayment last year continuing to this year, there is a time when borrowers are being bumped around between repayment plans, and there are interest capitalization events. There's potentially a lot of confusion around what needs to be paid when, and the entity or entities that bear the brunt of this is not the federal government. It is the loan servicers. And so, if you are part of a company or a state instrumentality that is servicing federal student loans, I would expect to see a significant amount of litigation, as we always have, coming out of this period of turmoil, because you're going to have putative class actions in which people are saying, across the board, the servicer missed the message from education, or they put borrowers into a particular status that was not appropriate. And there will be both state attorney general pressure and litigation pressure coming out of that. And I think that's going to happen regardless of how well empirically those servicers do during that time. A further thing exacerbating that concern is the fact that collection on defaulted loans resumed on May 5th after a 5-year hiatus. So, there are a lot of people who, in living memory, so to speak, they do not remember having collections efforts on their loans, even when they're not paying anything. In other words, it's been largely consequence-free for quite a while now. And TransUnion, one estimate I saw was that TransUnion estimates that 5 million borrowers may default between now and September of this year. That's just in the next couple of months. And there are a lot of things that may be startling to people, wage garnishment, involuntary wage garnishment that does not require a court order. And so people are going to see things taken out of their paycheck unexpectedly. That is going to result in litigation, I guarantee it. And the federal student loan servicers, again, are likely to bear the brunt of that because, unlike the federal government, their path to tort immunity is much narrower. Okay, a couple more cases here that I'll touch on. There was a very large multi-district litigation consolidated in the Eastern District of Pennsylvania against both the Department of Education and Fed Loan Servicing relating to very broad swaths of servicing on the TEACH grant program, implementation of income-driven repayment, and public service loan forgiveness. We at Ballard filed a motion to dismiss in September 2020 on these issues. Remarkably, that motion was pending with really no material development in the case until February 2025, when the court dismissed the entire action, granted our motion to dismiss, after finding that the claims of all plaintiffs withstanding are moot based on the department's remediation initiatives. The reason I mention this is because, again, if you are an entity with potential exposure related to federal loan servicing or even private loan servicing where there were remediation efforts in some respects, that matters for these lawsuits. So here, the Department of Education obviously had some very well publicized and sweeping changes relating to income-driven repayment and PSLF, where they started counting or crediting a lot of periods that they had not earlier credited. And in this particular case, the court took a look at that and said that when you look at what has happened since the complaint was filed, the claims are moot. None of the harm that was alleged in the complaint is sticking, so to speak. And so that argument may continue to have traction for any borrower who is trying to file suit based on alleged servicing errors that happened in 2024 or earlier. A lot of that's going to be caught up in these federal remediation initiatives. So just something to keep in mind if you find yourself in that scenario. Last, and another case that Ballard here was involved in, Caldiero v. Mohila. FIA was also a defendant in this action, as was a private lender. This was pending in the Middle District of Pennsylvania. And in February 2024, a borrower filed a putative class action under RICO, the Racketeering and Influenced Corrupt Organizations Act, as well as state consumer protection law, in which they alleged that the servicers and the private lender had conspired to deprive the borrowers of PSLF benefits following private loan consolidation. In other words, the allegation was that the loan servicers would work together with the private lender to get people who were otherwise PSLF eligible to consolidate into private loans and then lose their PSLF benefits. Now, we moved to dismiss in that case, and the court granted the motion to dismiss, finding that there was, for some technical reasons under RICO, the borrower had only alleged essentially one phone call in which one thing was said. And if you're at all familiar with RICO litigation, it requires a series of predicate acts. It requires continued criminal activity. It was a statute that has seen its strongest exercise in mafia-related, criminal corrupt organizations. And so we were very pleased to see the defenses vindicated in this case. And the takeaway that I would offer is that student lending and loan servicing, as probably everybody in this call knows, is extremely complex. It's far more complex than mortgage or auto servicing, and both of those are already pretty complex in some respects to begin with. So what happened on any given borrower's case, so to speak, is highly context dependent. Who said what, when, what do the records show, why did the person make certain decisions about their repayment plans or about consolidation? And so efforts to litigate these claims on a class or representative basis, which is always what plaintiffs' attorneys will try to do, those efforts are challenging. And based on this and from the previous case I just mentioned, you can see that there are many defenses that can be raised at the pleading stage to resolve these cases before they even get into discovery. For those who are inclined to do their own legal research, there's another case, Dawson v. Great Lakes, which represented the end of a very long-running saga against Great Lakes in connection with some other loan servicing, and the Seventh Circuit there affirmed the grant of summary judgment in the defendant's favor. And so again, another outcome where the court concluded that the alleged issues were fully remediated and no private relief was warranted. Okay, I'm going to pass it to John now to cover some of the state legislation that we've been waiting to hear about.
Thanks, Tom. I'm going to talk about a number of state legislative developments. I've extracted the ones that I think are most significant. We have a couple of bills that went through the legislature, were passed, and then signed by the governor. And then we also have a couple bills that have gone through the legislature and been passed, but they are waiting signature by the governor, or in one case, awaiting delivery to and signature by the governor. And then I'm going to talk about one bill that was introduced in California that doesn't seem to be going anywhere, but I think may well be indicative of the wave of the future in connection with student loan legislation. Now, one observation at the start, Tom mentioned that there's going to be, and this is pretty obvious, a greater opportunity for private loans in the graduate and parent space. There haven't been any legislative developments around that. I don't know, probably premature at this point because the one big beautiful bill just passed. But those kinds of loans have never been singled out for specific legislative action, and we may see that happening as we move through the year. So let me start with legislation in Connecticut. There are a number of states that have in their student loan servicing statutes provisions regarding cosigner release. And those provisions seem oddly placed because really cosigner release is something that's dictated by creditors and holders, not so much servicers. But there are extensive provisions in a number of these statutes requiring notification at inception, notification through the annual notification through the loan servicing, reminders that criteria have been met, provisions that preclude penalizing borrowers and cosigners who request a cosigner release. But all of these statutes have a similar, for want of a better term, I would say defect, in that it's not at all clear whether these statutes mandate the creation of a cosigner release program or whether these statutes simply address requirements that must be incorporated should a lender incorporate a cosigner release program into its student loan programs. Connecticut seems to be trying to address that in recent legislation. It's not entirely clear that that's what they did, but they adopted a statute that says that on or after October 1st of this year, any person that makes or extends a private student education loan shall provide options for cosigner release. Now, it's not entirely clear what options for cosigner release means and what the criteria can be. The only things that are really spelled out in the statute are that one criteria that can be included is a requirement for 12 consecutive on-time payments by the student loan borrower. That seems to be teed up in the statute in such a way that that's the maximum number of consecutive on-time payments that can be required. And then there's a requirement to release the cosigner in the event of total and permanent disability of the cosigner, and sort of incorporating release provisions that appear elsewhere in the student loan servicing statute. A lot of unanswered questions about this statutory provision. Just what are the options that have to be available? What are the criteria that have to be satisfied? How much flexibility, if this is required, how much flexibility does an originator of private student education loans have in setting criteria for cosigner release? And these are kind of odd statutes from a policy perspective, since one of the prime benefits of having a cosigner is that the defaults on private education loans are significantly lower than the defaults on federal student loans. And that makes a lot of sense because students going to school have no track record and haven't graduated, don't have jobs, and need this support. And to suggest that the release must occur only after 12 consecutive on-time payments seems misplaced. That doesn't seem to be what's required, but we have had conversations in the past with Connecticut where they have waffled on whether creditors currently have to include provisions for cosigner release, whether that is a requirement only if the creditor both has originated and is servicing the loan, or how that applies, and then what those criteria can be, because there seems to be a lot of room here for high standards for credit criteria for cosigner release. It's unclear whether one option might be to require that, for example, 90% of the loan be repaid, regardless of the number of consecutive on-time payments that happen to be made before there can be a cosigner release. Discussions that we've had in the past with Connecticut have not indicated a particular focus on these criteria that are going to be established, but we may see a greater focus on that in the future. Now, the one thing about the statute is that it doesn't apply to regulated financial institutions, and there's some policy sense there, since there are safety and soundness issues here that would seem to be outside the purview of the state of Connecticut. But non-financial institutions originating loans to Connecticut residents are going to have to grapple with the statute. And we're likely to see this replicated in the other states that currently have cosigner release provisions that aren't as strongly tilted towards a mandatory release. Let me talk a little bit now about legislation in New York about private education debt reporting. New York had an interesting period here of legislative developments from the end of last year and the beginning of this year, where they first passed a law that required creditors to provide information for a private education debt registry, both requiring registration with the state and then also requiring detailed information. That law never went into effect. Instead, New York passed a new law that didn't require creditor registration, but instead required servicers to report extensive information about private education creditors and private education debt. And that law sort of simultaneously took effect and trumped the law requiring the creation of a private education debt registry. Now, there are other states that have toyed with these registrations and information registrations. And it's pretty clear that what seems to be going on here are that the states are, through the registration process, or reporting process, collecting information that's going to drive state enforcement initiatives going forward. One of the clear things they want to do is they want to find out who's got the greatest market share in the state, so they know which servicers to focus on. And they're accomplishing that by requiring reporting about portfolio size and then requiring reporting about changes that occurred over the past year. The other thing that they're requiring reporting on is the creditors that have the most defaulted debt. Again, there's reporting requirements based on total defaulted debt and changes over the last year. And I think the suggestion is that a creditor that has a high percentage of defaulted debt may expect to receive an inquiry from the state as to what's going on, and in particular, what schools the creditor is dealing with and why there are so many defaults. But again, something to be well aware of as we move into an environment where the CFPB is not going to be active and states are going to take over the role of being the leaders on private student lending enforcement actions. Another point that the state is clearly focused on is the extent of non-payment defaults. And while there's not specific reporting on what those non-payment defaults are, I think we're going to see inquiries from the states if there's any significant percentage of non-payment defaults, what those defaults are, why non-payment actions are being deemed defaults that result in acceleration and collection. Another area of focus, not surprisingly, cosigner or guarantor practices. Another area of focus, refinancing of private and federal student loans. That may be less significant now that we don't have the tremendous range of federal student loan payment plans, and and disclosures about the loss of federal student loan benefits may be much easier to provide going forward. But then also a focus on collection actions, and in particular, debt collection lawsuits. So New York is going to make some lists. They're certainly going to be checking them. And then in addition to this reporting, there's a direction to the state to set up a website in the next 2 years where the state provides information about the servicers that are servicing loans in the state, name, address, telephone number, website, and then connects to that information a summary of the reported information about the activities that have occurred with loans that are being serviced by that servicer. It's not entirely clear what that's intended to accomplish, in the sense that there's no suggestion in the statute that borrowers should somehow be able to change servicers, although that's obviously been a constant point of emphasis from the CFPB as to why greater focus is required on servicers. But we'll see how that plays out going forward. So those are the two laws that have passed. Let me now talk about two laws that have made it through the legislature but haven't actually been signed by the governor at this point. One significant one passed in Illinois, and it amends the student loan servicing law. This is kind of an odd placement for these legislative provisions, to add an Article 7 on educational income share agreements, and provides the rules of the road for offering educational income share agreements in Illinois, and maybe will, through this action, kind of revitalize the income share agreement product. Now, I noted that it was enacted on June 20. It hasn't yet been signed. It's clearly drawn the ire of the Student Borrower Protection Center, and there's some concern about the length of time that has occurred here, although it will become law if the governor doesn't act within 60 days, because there's no pocket veto in Illinois. But you might expect, or I think we all expect, that there's a fair amount of lobbying going on to try to persuade the governor to veto this law. The law creates both substantive restrictions and disclosure requirements on income share agreements that will be permitted. I've listed some of the substantive restrictions here because I think they're fairly significant. There's a limit on the amount of a consumer's income that can be obligated that is, in some respects, lower than what we initially saw as income share agreements were being rolled out. It's 8% of the consumer's income. And there's an additional cap on total income that can be allocated to income share agreements and educational loans measured at the time of origination. The law sets an income threshold in order for a borrower to be required to make income-based repayments. Their income has to exceed an amount currently set at $47,000. That amount is going to be adjusted annually. I think it's a little uncertain as to whether that annual adjustment is supposed to flow through to the income share agreement. I think not. I think this is intended to be an amount set at the outset of the origination, so that as we proceed, entities that are offering income share agreements will have to adjust the threshold in their documentation each year. But those changes don't relate back to prior originated obligations. There's a rate cap set at the greater of 9%, or a rate determined by looking at the last auction of 10-year constant maturity treasury notes at the end of the prior calendar year and then adding 6%. There are term limits. There's a maximum for 180 monthly payments, and payment pauses are regulated by the statute, and there's also a limit on the amount after which the obligation has to cease to exist. So none of these can go beyond 20 years. There are numerous and very detailed exclusions from the income that can be allocated to an individual and counted in determining whether their income exceeds that threshold. They're the sort of things you might expect, but in addition to including spousal income, retirement income is excluded. So IRA distributions, pensions, annuities, Social Security benefits are all ruled out, as are various forms of governmental aid. Again, the law also includes fairly detailed disclosure requirements. Happy to discuss those offline with anyone who would like to talk about them. It's not yet in effect, and I guess we're going to have to wait another 60 days to, maybe wait up to another 60 days to see whether it will take effect. Now, there's a bill that has passed in the New York legislature that focuses on a kind of financing of education that is a little bit less traditional, and that's employer finance training. These programs had drawn the attention of the CFPB. The Student Borrower Protection Center had campaigned for the CFPB to step in and push these out of the marketplace. The Federal Trade Commission had also stepped in its proposed elimination of non-compete agreements and purported to rule them out as a kind of non-compete agreement. But those regulations are in limbo and may never go into effect given the litigation that's ongoing. So what I think we're going to see is continued efforts by the Student Borrower Protection Center to have statutes like these enacted in as many states as possible, sort of like we're replicating the spread of student loan servicing laws all over again. And what this statute does is it basically prohibits the use of employment promissory notes, which are defined as instruments, agreements, contract provisions that require a worker to pay an employer a sum of money if the worker leaves employment before the passage of a stated period of time. So they're clearly intended to address employer financing of training programs where if the employee leaves employment and takes the benefit of that training, they'd have to repay the amount of money that had been advanced by the employer. I've included this because from time to time we've had some inquiries about the servicing of these obligations. And I think that if you're interested in this space, you're going to have to watch the developments here very carefully. This statute precludes the recovery of funds advanced for training expenses, makes the contract or the contract provision null and void, and it opens the employer to the possibility of a fine, with each agreement being a separate violation, subjecting an employer to a minimum fine of $1,000 or a maximum fine of $5,000. Now, I mentioned at the outset that it's kind of in limbo. If I got these time periods correctly, the New York legislative session ended on June 18, but the legislature still has 45 days in which to send this bill to the governor, and apparently it has not yet done so. And then the governor has another 30 days from when the bill was when the enacted bill is sent to her, in which to make a decision. And failure to act here in New York does result in a pocket veto, unlike the case in Illinois. By the way, the New York Fair Business Practices Act, which was going to extend New York's laws governing unfair acts and practices, is in this same kind of limbo, and that bill has not yet been delivered to the governor, even though it did pass the legislature, and you've probably seen numerous reports about it because of its potential significant impacts, not just in the student loan and student loan servicing space, but more broadly, since it would empower the New York Attorney General basically to act as a consumer financial protection bureau. Let me mention now one piece of legislation that has been introduced in California. It's actually been introduced and reintroduced a couple of times, but I think it's an indication of legislative developments that we might see in the future, not just in California, but in a number of states. You probably all recall that just at the time of the change in administrations, the CFPB had seemed poised to direct its focus to institutional debt. loans or retail installments contracts extended by colleges and universities, career schools, etc., providing for financing of generally attendance, but also in some instances other amounts incurred by a student attending the school. Now, this hasn't gone anywhere. It's in committee. It didn't go anywhere last year, but it includes a number of provisions that make it harder for schools to try to collect debt through the enrollment process. It prohibits a school or university from charging a higher tuition or a fee for enrollment if there's unpaid institutional debt, and it prohibits or would prohibit a school or college from prohibiting a current or former student from enrolling or registering if they have institutional debt. There's a one-time exception that allows for a student to come back and re-enroll on sort of a mandatory exception. Again, that's something I'd be happy to talk about offline with anyone who's interested in it. And then it goes on to require institutions to have written policies and procedures defining standards and practices for collecting debt. Then there's sort of almost like a notice and right to cure provision in this statute, where institutions are required to make reasonable efforts to contact current or former students sort of at the outset of the collection process to notify them of their debt. And then there are very detailed notices that would be required before institutional debt could be assigned out to a third-party collector. And in a provision that sort of replicates what we've seen states doing with medical debt reporting, there's a provision in this law, or in this bill, that would prohibit institutions and third-party debt collectors from reporting any institutional debt to consumer reporting agencies. So while that is kind of an odd thing to have appearing in these statutes and seemingly penalizes people who pay their debts, it does appear to be an effort to take institutional debt out of the credit reporting system. The last piece of litigation that I wanted to talk about is a settlement that was recently announced by the Massachusetts Attorney General with Earnest. And this settlement agreement was signed earlier in July, on July 8th. There was a press release that came out about it on July 10. I think it's pretty clear that this investigation must have been initiated during the Biden CFPB, and then it continued on and has recently concluded. It illustrates the use by a state attorney general of a statutory provision prohibiting unfair or deceptive practices to reach fair lending issues and artificial intelligence issues, notwithstanding somewhat of a dearth of state legislation on those topics. It's very focused on private loan origination underwriting, and then private loan origination adverse action notices. There were a series of problems identified with the underwriting, both the use of judgmental overrides, I'll come back to that, the automated underwriting system itself, and then knockout rules that were in place prior to any automated underwriting or judgmental decision-making. Noteworthy, I think, for all of us is that the Commonwealth objected to the use of immigration status as a knockout rule, and it asserted not that there was a disparate impact here, but that there was a risk of disparate impact that apparently was so high that a lender could not require that a applicant be a permanent resident of the United States. It made the equation that immigration equals citizenship equals discrimination on the basis of national origin. And I think this is really interesting because in some respects, it's probably the opposite of what we would see the Trump administration insisting on. So it's a development that I think we want to watch very carefully. The two other developments, one was the use of the cohort default rate in automated underwriting, which was simply asserted to result in disparate impact automatically. And then the other underwriting issue involved use of judgmental overrides to approve people who otherwise would have been knocked out by the automated underwriting. And the problem with the judgmental overrides was, although underwriters had a list of criteria they could use in deciding whether to override the score that came out of the automated underwriting system, and that allowed them to look at things like career, degree, and job, there were significant inconsistencies and variations from underwriter to underwriter as to how those factors were applied. Adverse action notice violations resulted in part from the way the system was designed. Initially, the system apparently only provided very limited options in a drop-down menu, and those options for adverse action reasons didn't necessarily align with the reasons for the decision. There was a subsequent improvement to the system to provide for a other kind of box with associated options for the other category. But again, those options didn't match all of the criteria that were being used for making decisions. And then, as the CFPB had alleged in some of its releases, there was a concern about the specificity and the accuracy of the reasons for adverse action that were generated by the artificial intelligence models, and also a concern that the reasons were kicked over to underwriters or individuals to review, and they simply didn't have the necessary background to be able to review the decisions made by the models and provide reasons for adverse action. So where did this all end up? A $2.5 million payment to the Attorney General, fairly extensive requirements to implement a corporate governance system for the use of artificial intelligence models, a requirement to adopt written policies and procedures for the same, and semi-annual reporting back to the Attorney General over a 4-year period.
I think I'll speak for both of us and say we really appreciate everybody's attendance here. We have an exciting list of upcoming programs you've already heard about. Please reach out to us with any questions you may have. Thank you very much for attending today.
Thank you all.
To make sure you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights about the consumer finance industry. And if you have any questions or suggestions for the show, please email us at podcast, that's singular, at ballardspire.com. Stay tuned each Thursday for a new episode of our show. Thank you for listening and have a good day.